Clark, let's talk for a minute about statutory law specifically and how that relates to DWIs.
DWIs are defined by statutes. North Carolina General Statute 20-138.1 is the statute that defines what a DWI is. It lays out the 5 different elements. 1, who was the driver of the car? The state's got to prove you're the driver. 2, they've got to prove that there was operation of a vehicle. 3, they've got to prove it was a motor vehicle. 4, they've got to make certain that they can prove that you were on a street or a public vehicular area. And of course, the most important one is they have to prove you're impaired. Now, there's 2 different ways to prove impairment. You can either prove it with a chemical test, such as a blood or a breath test that comes in at .08. Or they can prove it by evidence of bad driving, bad field sobriety tests, and those other evidence of impairment. But those are just the statutory elements. In addition to that, the statutes lay out very strict procedures that the state must follow in blood and breath testing. And so you've really got to be on top of the statutes, and we've got to study that in your case to see whether or not they've complied with all the regulatory processes. And then last of all is sentencing. And of course we'll talk in greater detail about that, but that's all laid out by state statute.
And reasonable doubt too. I mean, that's something I've heard on television before, when there's reasonable doubt. That's a factor too, right?
Reasonable doubt is a factor. That really goes more to the jury and the judge at the final end of the case.
All right, thanks Clark. We're going to go more into specifics on elements of the crime and other things, but we'll do that next.